can hope for.
Well, we've not had a conversation with you. The last time we had a conversation was before the Supreme Court made the decision. I'm sure you heard everything people have said about that decision.
Yes.
What do you think?
I think the Supreme Court is being used as an agent to destroy the constitutional governance of our country. And it is very bad. The judiciary is obviously the last bastion of the defense of our Constitution. And when it becomes an instrument of destruction, then seriously, Ghana is in trouble. The decision of the Supreme Court is so ultra-virus, beyond its jurisdiction. It has no right to put a brake on parliamentary proceedings. It's not only the principle of separation of powers that dictate that the Supreme Court should behave itself, but also the very constitution that created the Supreme Court also created Parliament, gave Parliament its powers and more or less the space that it needs. The standing orders of Parliament has the same force as that of the Supreme Court. They are both creations of the Constitution. So, where does the Supreme Court get the notion that it has a right of interpretation of parliamentary proceedings? This is not an act of Parliament that you say is in conflict with the constitutional provisions. The Speaker never made a ruling, nor did he interpret Article 97 and its subclauses. Those articles kick in as a matter of automatism. Automatic. It's like the criminal law of liability, strict liability. And you see, when you're dealing with a matter that bears on strict liability, like driving without a license, the prosecution doesn't have to prove anything in your mind that you had a mens rea to commit the offense. You have committed the offense, period. Article 97 imposes an obligation on the member of Parliament who crosses carpet or reneges on his independence status. It kicks in. What the Speaker did was to declare the act is at clear. And when an act is at clear, where does the Supreme Court get the audacity to come and interpret?
So you're saying that the Supreme Court has no authority because you use the ultra-virus, which means outside their power?
Yes, it is. They are forever precluded from interfering with parliamentary proceedings. Otherwise, our constitutional governance has no meaning. We do not have a supra-constitutional body. The Supreme Court cannot set itself up as a supra-constitutional body. All it has is the jurisdiction to interpret an act of Parliament that is at variance with the Constitution. It cannot review the Constitution. It doesn't have the power to review the Constitution. If there is a need to review the Constitution, it must go through a constitutional process, not the Supreme Court.
Well, because they say in that judgment that the subject matter of the suit raises real questions of constitutional interpretation.
It does not. What did the Speaker do? That amounts to interpretation. The Speaker did not make a ruling. Acting under the authority of the standing orders, he informed the House. The obligation is on the part of the parties affected, the four MPs, to vacate their seat, because the provision of Article 97 says you must vacate your seat. Period. Now, the next question is whether there is evidence that they have transgressed, and the evidence is clear that they have transgressed. They have filed to contest elections as independent candidates, and the independent candidate has reverted to a political party. This is a denial of your contractual obligations to the party and to your constituents, in which case you have an obligation to vacate your seat. All the Speaker did was to inform Parliament accordingly.
Be that as it may, and I'm sure you're monitoring what is transpiring in Parliament, where
Yes.
the MPP caucus basically has walked out because they feel that they should be sitting on the right side of Parliament. That's the majority side because of the decision of the Supreme Court. What do you make of that move of theirs?
How can you say that because of the decision, when that decision is flawed, fundamentally flawed? It acted ultra vires. So how do you use that as a foundation for your action? It means you are not behaving in accordance with the Constitution. You are also a threat to the Constitution. Look, Supreme Court, Parliament, the Presidency, none of them is a sovereign entity in Ghana. The only sovereign entity is the Constitution of the Republic of Ghana, representing the will and aspirations of the people of Ghana. We are the sovereign people who have put down our will and aspirations in a written constitution, and therefore the supremacy of the realm rests with the Constitution. Any act that interferes with the letter and spirit of the Constitution is treasonable.
How is the Speaker to handle this?
He should stand firm. He is right in what he did, and he should put his foot down and not budge. We cannot continue to entertain a judiciary that is constantly chipping away at our constitutional principles. It shouldn't be allowed to happen.
You should stand by his decision. You're saying he did the right thing.
He did the right thing.
That will amount to ignoring the Supreme Court.
It will amount to what?
Not going by the Supreme Court's orders.
Why should the proceedings of Parliament be subservient to the Supreme Court? This is not an act of Parliament that calls for interpretation. The provisions of Article 97 are not subject to interpretation. They operate automatically. The letter and spirit of that provision is clear. It does not call for interpretation. And the Supreme Court has no right to go and interpret something that is not subject to interpretation.
Doc,